by showing to the court that this particular problem that has taken place is an inherent risk. So, in the best of the hands, anywhere in the world, in spite of taking all the care and caution, certain problems are just inevitable. You just can't avoid it. So therefore, how do you prove? The best way of proving that this particular problem is an inherent risk is by keeping standard textbooks before the court. Standard textbooks can be placed which says that there is a risk of X% from this particular problem from taking place. So if at all you are able to keep 2 or 3 textbooks wherein you can highlight the fact that this is an inherent risk, I think you are out of the woods. Now, it might so happen that textbooks are silent on a particular proposition with respect to the inherent risks. In that case, what do? In that case, you can keep peer-reviewed journals or index journals in the court. Index journals, peer-reviewed journals also have the same effect as standard textbooks. But standard textbooks are always considered to be the gold standards, remember. If peer-reviewed journals are also silent on a particular proposition of this particular problem being an inherent risk, then what you can do? You can file expert opinions. Expert opinion means an opinion from some senior consultant who says that this problem can happen because it is an inherent risk. Here the problem was the damage to the tail of the pancreas when a left-sided adrenal tumor was being removed in an obese patient is an inherent risk. That was the proposition. And that is exactly what they proved with the help of textbooks. If suppose there is no senior coming forward to give you an expert opinion, I'm telling you ways of identifying. Then what you can do is, you can definitely ask the courts, ask the consumer courts or any other court to refer the matter, the file, to the civil surgeon or to a government hospital for an opinion. Mind you, this is a little tricky. This is a little dangerous. So you've got to be a little careful. So, I always put this rider whenever I say this. And the last way in which you can prove to the court is by keeping internet references. Now see, there is a lot of crap on the internet. So what does the court accept as evidence drawn from the internet? On the internet also, there are some peer-reviewed sites. For example, PubMed is a peer-reviewed site. So if at all you can take references from PubMed and you can place it before the courts do accept it. So if at all there is an inherent risk that becomes manifest, that inherent risk or that particular problem per se, in the eyes of law, is not negligence. That is what the Supreme Court is saying. And this is the obituary dicta. So I'm reading once again, now that you have understood what I'm saying. It says that we cannot take the benefits without taking risks. Every advancement in technique is also attended by risk. This is what the Supreme Court is saying. Now the next thing is, the Supreme Court also quotes certain laws, and one of the quotes that the Supreme Court invariably draws into its judgments are quotes from the English law. Because we people have imbibed the English system of jurisprudence, and the English laws are still very much applicable to the Indian laws, Indian courts, although they might not be binding upon the Indian courts, but invariably we have seen that the Supreme Courts take references or take the observations of the English courts. And this is one nice observation that the Supreme Court has quoted in this Kusumlata judgment, and that is why I have taken it. It says, it refers to the case, it says, it is so easy to be wise after the event and to condemn as negligence that which is only a misadventure. We ought to be, we means who? The courts, the judicial authorities. We ought to be on our guard against it, especially in cases against hospitals and doctors. See how beautifully it is put. So if at all there's a problem that has taken place at the hands of the doctors in a hospital, the Supreme Court says after the event has taken place, one becomes very intelligent. But that is not what is negligence. What you have got to see is that that particular point of time, whether the treatment given by the doctor was appropriate or not. See, it says we ought to be on our guard against it, especially in cases against hospitals and doctors. This is the observation in this case. I have not yet come to the 11 guidelines. These are certain observations which becomes important. Now, this is once again the same thing that comes in. It is referred again by the Supreme Court. It is reiterated again by the Supreme Court. It says, medical science has conferred great benefits on mankind, but these benefits are attended by unavoidable risks. Every time when I stand in the court and I quote this paragraph, I harp on this word unavoidable. Unavoidable means what? Every word in the judgment becomes important and can be interpreted. It is all up to you as to how much importance you give to that word. What do you mean by unavoidable? Unavoidable means even if you try your level best to avoid it, sometimes you cannot do it because the situation is such where even in the best of the hands, this particular problem can take place. Let's go ahead. The Supreme Court in this very judgment says, see, this judgment is a boon to an advocate who defends the doctors. See, it says, but we should be doing a disservice. We means who? The courts, the judicial authorities, the quasi-judicial authorities. It says, but we should be doing a disservice to the community at large if we were to impose liability on hospitals and doctors for everything that happens to go wrong. Can you have it anything better than this? This is when you have to tell the courts, see, this is what the Supreme Court says. So just because something has gone wrong, that ipso facto does not mean that there is negligence on the part of the doctor. Negligence is something that has got to be proved, and the burden to prove this is always on the person who claims the negligence, that is the patient, correct, or the patient's relatives. So nothing, if something goes wrong, that doesn't mean that there is negligence. You cannot confer or infer that there is negligence, and that is why this has happened. Now let's go ahead. Now these are the 11 guidelines that the Supreme Court has laid down. The first guideline, the Supreme Court says that any judicial authority has got to consider these 11 points before you decide a case of medical negligence. And I'm once again saying, if at all these 11 guidelines are really followed by the authorities, we doctors will never lose a case in the courts. Now let's see what those guidelines are. It starts from here. The first guideline that the Supreme Court says is, negligence is a breach of duty exercised by omission to do something which a reasonable man, guided by those considerations which ordinarily regulates the conduct of human affairs, would do, or doing something which a prudent and a reasonable man would not do. Of course, we all know this. Negligence can be an act of commission or an act of omission. Act of commission is you have committed an act which a reasonable, prudent doctor would not do. That is, suppose you operate upon a patient of ectopic pregnancy with hemoglobin 4 without keeping blood ready. Well, that is negligence. There's a placenta previa patient, you open up the patient without keeping blood ready. That is something which a reasonable, prudent man would not do. Correct, na? An act of omission means what? You omit to do something which a reasonable, prudent doctor would do. For example, a simple thing, ophthalmology, cataract. Well, you do not take the tonometric readings. You don't know what the pressure is. There is a lot of pressure built up in the eye, and when you slit the cornea, the whole thing comes out. You know, measuring the pressure, intraocular pressure, is mandatory before you do a cataract. And if at all you don't measure the intraocular pressure, and you do a cataract, and there is such a problem that takes place, it is an act of omission. Something which is very clear. Next. The Supreme Court says item 2 that needs to be decided, that should be kept in mind by the courts, is that negligence is an essential ingredient of the offense. The negligence to be established by the prosecution must be culpable or gross, and not the negligence merely based on an error of judgment. What is important are the last 3 words. Supreme Court says that an error of judgment is not negligence because in this particular Kusumlata's case, what had happened was, clinically before surgery, the doctors told the patient that because the tumor is well encapsulated, it is unlikely to be malignant. Correct? Had it been a malignant tumor, that the capsule would have been breached in multiple places. That is one of the ways we are taught. And that is exactly what the relatives were told when they were counseled. Supreme Court says, in this particular case, the histopathology report turned out to be malignancy. There was an absolute change in the diagnosis. There was an error in judgment when the patient was examined clinically, preoperatively. Supreme Court says no, an error of judgment is not negligence, more particularly when there is due application of mind before that particular provisional diagnosis has been arrived at. I'm once again saying, whenever you come to a conclusion after due application of mind, if at all your diagnosis, your conclusion is wrong, that conclusion in the eyes of law is not considered to be negligence. The most important word is due application of mind. That's what I said, na? When you come to a conclusion after due application of mind. Now, what do you mean by due application of mind is the next question that you'll ask me. And the concept of due application of mind means, first thing is, when the patient comes to you, you've got to take the history of the patient. Take the patient's history in detail. Second thing is, you've got to thoroughly examine the patient. And the third thing is, you've got to investigate the patient the way you feel investigations are required. And based on these three, you've got to come to a conclusion. That conclusion, even if at all it is wrong, in the eyes of law, it is a conclusion that you have derived at after due application of mind. And if at all, such a conclusion is wrong in the eyes of law, that is not negligence. And invariably, we medicos understand that this conclusion that you arrive at is always within the ambit, is always within the ambit of the differential diagnosis. Within the differential diagnosis. So this is what the Supreme Court says. Okay? So don't worry, if at all there is error in diagnosis, that error in diagnosis per se does not mean that there is negligence, but make it a point to see that these three parameters are present. You must be able to prove to the court that due application of mind was there, and everything is within your capacity to show it to the court. Okay. Now, the third thing is, the medical profession is expected to bring a reasonable degree of skill and knowledge and must exercise reasonable degree of care. Neither the very highest nor the very low degree of care and competence judged in the light of the particular circumstances of each case is what the law requires. See, remember this. There can be, in NANDED, there are so many beautiful surgeons, top. And there also may be surgeons who are third class. Possible. Everywhere it is possible. Can you say that that particular surgeon is so good and you have messed up my case? No. The law does not expect you to be the best surgeon. Neither does the law expect you to be the worst surgeon. If at all you are somewhere in between, that is good enough. Remember this. So law does not expect you to be the best. You should not be the worst. If you are somewhere in between, if you are reasonable, that is good enough. So don't worry. There might be better people than you. There might be worse people than you. As far as you are somewhere in between, that does your job. Now the Supreme Court says, the fourth criteria, a medical practitioner would be liable only when his conduct fell below that of the standards of a reasonably competent practitioner in his field. The word is reasonably competent. That is important. So what law expects you to be is reasonable. Neither the best nor the worst. If at all you are somewhere in between, that is good enough. Because this invariably, these issues are taken up in litigation. That particular surgeon is so good, his results are practically 100%. And look at this surgeon, he has messed up my case. That is how it is taken. Now, once again, in the realms of diagnosis and treatment, there is scope for genuine difference of opinion. And one professional doctor is clearly not negligent merely because his conclusion differs from that of another professional doctor. What does this mean? You take my opinion, you take a second opinion. The second opinion might be completely contra to my opinion. Does that mean that both the doctors are guilty or the first doctor is guilty? No. No. You are entitled to your opinion. Just like the judges. You know, the High Court judge might give you a particular kind of a judgment and the Supreme Court will reverse it. So there can be as many judgments as there are judges. In the same way, there can be as many medical opinions as there are doctors. Remember, I'm entitled to my opinion. And when I give an opinion after due application of mind, even if that opinion is wrong, the law will not hold it against me. You know, so such nice things. Now see, sixth, the medical profession is always called upon to adopt a procedure which involves higher element of risk, but which he honestly believes as providing greater chances of success for the patient, rather than a procedure involving lesser degree of risk, but a higher chance of failure. Just because a professional looking into the gravity of the illness has taken higher element of risk to redeem the patient out of his or her sufferings, which did not yield desired result, this may not amount to negligence. What is the reference? I'll tell you. See, in this Kusumlata says, I told you, the surgeon opened the patient from the anterior route. That's what I said. Correct, na? In the process, he had to go transperitoneal, go behind, remove the spleen, go behind, and remove the adrenal tumor. That is what he did. There is another way in which this particular problem could have been tackled, and that is you go by the retro approach, the way you manage a kidney problem. You can go from behind. You don't open up the peritoneum at all. You can still remove that tumor. Okay, there are two approaches. Now here, one of the allegations made by Kusumlata was in the Supreme Court was that had the doctor removed the adrenal tumor from the posterior approach, there would never have been a possibility of damage to the tail of the pancreas. This was one. The Supreme Court says anterior approach is a more difficult approach. But then the doctor decided to go by the anterior approach because the doctor felt that it was better for the patient, and in the judgment it is written. It was the doctor's case that when he went transperitoneal, he was able to examine the other organs like the liver, the peritoneal, the para-aortic lymph nodes, everything he could have seen. And that is why he went through the difficult line when he knew that there was a simpler line available. No, that doesn't mean that. That is what it says. Now, negligence cannot be attributed to a doctor so long as he performs his duty with reasonable skill. Once again, the word is reasonable skill and competence. Merely because the doctor chose one course of action in preference to the other one available, he would not be liable if the course of action chosen by him was acceptable to the medical profession. Very simple, I will not take time. See, the eighth point that the Supreme Court says must be considered is, it says, it would not be conducive to the efficacy of the medical profession if no doctor could administer medicine without the halter around his neck. Today what happens is every doctor has got this halter around his neck. He is worried about litigation. Mind you, litigation is a bad thing to have because you lose your sleep. It's not something, because I deal with all doctors who have problems, and invariably it's a nanny shoulder that you have got to give them to keep their heads and cry. That is they literally do, but that is the way it is. Then what this observation is made. Now, the next one it says, see, this is important. It says, it is our bounden duty. Our means who? The courts. The Supreme Court says, it is our bounden duty and obligation of the civil society. Now, the problem is, for every small thing that happens, you put it in the civil media. That is so sad. The Supreme Court has made a reference here. And the obligation of the civil society to ensure that the medical professionals are not unnecessarily harassed or humiliated so that they can perform their professional duties without fear and apprehension. So this is a rising, and that is why this particular observation is made. And therefore, if at all you can show to the court that he is using the social media to malign me, to defame me, I think today the courts, with this particular reference, will be able to take action against the person and maybe might take, give you a positive result. Next, it says, the medical practitioners at times also have to be saved. Remember, Supreme Court is saying this. The medical practitioners at times also have to be saved from such a class of complainants who use criminal process as a tool for pressurizing the medical professionals, hospitals, particularly private hospitals or clinics, for extracting uncalled for compensation. Now, this is what is the rule today. They first go to the police station and they lodge a complaint, okay? And then they start pressurizing the police. And then what they do? They file a complaint in the medical council. And then what they do? They file a complaint in the consumer courts. So there are three avenues opened up. And all three avenues simultaneously are on. Just imagine the kind of pressure that comes on the doctor. It is with this in mind that the Supreme Court has said this. I'm reading it again. The medical professionals at times also have to be saved from such a class of complainants who use criminal process as a tool for pressurizing the medical professionals stroke hospitals, particularly private hospitals and clinics, for extracting uncalled for compensation. Such malicious proceedings deserve to be discarded against the medical practitioner. See what a beautiful statement it is. But then it has got to be implemented. And it can be implemented only when this particular judgment is placed before the judges and say that this is what the Supreme Court says. And these are the medical council complaint. This is a criminal complaint. This is a consumer complaint, all against me, filed by this particular complainant. The entire outlook changes. And lastly, the 11th guideline is, the medical professionals are entitled to get protection. See how beautifully it is put. The medical professionals are entitled to get protection so long as they perform their duties with reasonable skill and competence and in the interest of the patient. The interest and the welfare of the patients have to be paramount for the medical professionals. So the courts are saying today that we are to be protected. But for this, you've got to go to the Supreme Court, and that takes practically 20 years. A lot of people die during the process. But when such judgments do come, we people should encash upon such judgments and show it to the courts below that this is what the Superior Court has said, and Article 144 makes it binding upon you to follow it. And that is why I've always been saying, today, with this particular judgment and Jacob Matthew judgment, if both these judgments together are relied upon in the courts, Article 144, Supreme Court, it is very difficult to lose a case. It's very difficult to not win a case. And when there is a resistance in spite of this, then you know what happens? Tutu meme. Now you understand? Tutu meme happens. But then it is all right. As an advocate, nice, gammat karachi savai. As an advocate, it is my job. I don't stand against the doctors of the medical fraternity. Never. I'm doing this since 1991. 34 years now. Never stood a case against, not even one case. I don't even advise them. But then, as an advocate, it becomes my job to see that my doctor is out. And I will do anything possible for it. And that is a criteria or one of the characteristics of a good judge. So, ladies and gentlemen, God has been very kind to me. I've always been saying this. God has been very kind to me in the sense that, I can communicate well. I know both the sides very well. And I do help my practitioners. And I've always told my people, wherever I go, I've told my people, here is my number, take it. If at all there's a problem, help is just one phone call away. And mind you, this is not a financial proposition. There's no money involved. It is absolutely free of charge. I put it on paper. So take down the number. If you want any help, we are always there. Feel free to call us and we will help you out. This is courtesy. This is courtesy IMA. This is courtesy IMA. I think I owe it to IMA. I've been with you all since a very long time. And I think it will be a privilege to help IMA members if at all they are in trouble. Thank you, ladies and gentlemen.